and by the laws of our country. If someone is suspected of having broken law, the police may arrest him. But our Bill of Rights protects everyone, including those suspected of committing a crime. An accused person is considered innocent until proven guilty. His rights as a citizen are guaranteed by the procedures followed. Let's see what these rights and procedures are, and why they are important to us all.
Our unit checked marijuana swaps, and you have another possible pinpoint.
Chairman, in the Army Rear 723 millimeters, possible parking problem. Gentlemen, I know you've been told this before, but I would like to advise you of your rights.
Before a person can be questioned by the police, he must be advised of his rights. He cannot be forced to answer questions and has the right to be represented by an attorney if he so chooses.
I both understand this.
Yes.
If you have any questions regarding your rights, you're charged with 484 of the Penal Code, which is petty theft. Your bail will be $550. Also, you're entitled to make a phone call. You may call your employer, or you may call your lawyer, or you may call any relative or bail bondsman.
Hello, Martin. This is John. Yeah, I'm in a little bit of trouble. Yeah, that's right. Yeah, I need you to post bail, $550. Yeah, can you do it? As soon as you can. Right, fine.
I'd like to post bail for my cousin, John Newland.
John Newland?
Right.
Yes, sir. He's here on 484, and his bail is $506.
I think it's on.
Bail is an amount of money paid to allow an accused person to leave jail. This money is a pledge that the accused will return for trial. When he does, bail is returned to the person who paid it.
Okay, sir. He's going to turn for on Thursday at 9 o'clock in the morning.
Thank you very much.
You bet.
The Bill of Rights states that bail should be a reasonable amount. If no bail is paid, the accused must wait for his trial in jail. Following the arrest, the police officer prepares a detailed report of what happened. This report will be used when the accused appears in court. The first appearance in court usually comes within a few days after an arrest. This court appearance is called an arraignment. At the beginning of an arraignment, the judge explains the procedure and informs the accused of his constitutional rights.
A number of you here this morning are accused of misdemeanor violations of one kind or another, and this is the time for you to enter a plea of either guilty or not guilty to the charges against you. If you plead guilty, the court will no doubt pass judgment on you at this time. If you plead not guilty, you're entitled to have a trial within the next 30 days. You may have a trial by jury or a trial by the court sitting without a jury, whichever you select. You're entitled to use the process of the court to bring witnesses in to testify on your behalf without expense to you. You're entitled to be released on bail pending your trial, and you're entitled to be represented by an attorney if you choose. Now, we'll call the matter People versus John Newland and Roger Harley. Will those defendants come forward, please? You and each of you are accused of petty theft, in that it's alleged in this complaint that you stole hubcaps from a car not belonging to you.
The Bill of Rights gives an accused person the right to be informed of the charges against him. After being informed of the charges, he is asked whether he will plead guilty or not guilty. Before entering a plea, the accused has the right to get advice from an attorney if he chooses to do so.
Please, without the attorney being present to represent you.
I'll enter a plea now.
Very well. To the charge, how do you plead, Mr. Newland?
Guilty.
Mr. Roger Harley, are you ready to enter a plea to the charge against you without an attorney being present?
I don't think I'm guilty. I'd like to have a lawyer.
Mr. Harley, do you have any money or property or means of hiring a lawyer of your own choosing?
No, Your Honor.
Very well. The court will appoint a public defender to represent you. Mr. Williams, would you come forward and represent the defendant?
If the accused cannot afford a lawyer and faces a possible jail sentence, the court is obligated to provide a lawyer free of charge.
Is the defendant ready to enter a plea, Mr. Williams?
Yes, Your Honor. The defendant enters a plea of not guilty and requests a trial by jury.
We can set this down for a jury trial on October 5th of this year. Would that be a satisfactory date, Mr. Williams?
The date of October the 5th seems satisfactory with my calendar, Your Honor.
Would you like to be heard on the matter of bail, Mr. Williams?
Yes, I would, Your Honor. The defendant informs me that he is 21 years of age and has had no prior arrest, juvenile or adult. I'd like for the court to consider this information in deciding on the amount of bail.
Well, as you know, ordinarily, bail in these matters is the amount of $550. But in view of what you have said, Mr. Williams, I believe that a suitable bail would be $110. I'll order that the defendant be released upon the posting of bail in the amount of $110.
Thank you very much, Your Honor.
This is the time for your sentence, Mr. Newland. Are you ready to receive that sentence? I note, Mr. Newland, from your record, that you have been arrested and convicted 2 times before this for the same offense, that is, the petty theft. Is that true?
Yes.
Well, that being the case, I'm afraid, Mr. Newland, there isn't anything that I can do for you. I'm going to sentence you to 6 months in the county jail. Society certainly isn't going to put up with any more offenses on your part. Remove the prisoner, Mr. Bailiff.
An accused person who pleads innocent at an arraignment is given a trial. The Bill of Rights guarantees the accused the right to a speedy and public trial.
Everyone please rise. Face the flag of our country and recognize the principles for which it stands. Department 4 of the Municipal Court is now in session. The Honorable J. Merrill Lewis, Judge President. Please be seated on board.
To call this matter People versus Roger Harley. Is that matter ready, gentlemen? Very well. Mr. Bailiff, will you bring the jurors in, please?
At his trial, the accused has the right to have his case heard by a jury. The jury, made up of fellow citizens, listens to the evidence and decides whether the accused is guilty or innocent.
Mr. Prosecutor, you may call your first witness. People call Officer Loggins.
Prosecutor, a lawyer representing the people, presents the evidence against the accused.
Raise your right hand to be sworn, please. You do solemnly swear the testimony you may give for the cause now pending before this court to be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name, please.
Herbert M. Loggins.
Take this back, please.
Were you a police officer assigned to patrol for the city of Huntington Park?
I am.
You see the defendant Roger Harley and John Newland on September 18th of this year.
I did.
A person who testifies or gives evidence at a trial is called a witness. The Bill of Rights states that an accused person has the right to confront the witnesses who give evidence against him. He cannot be convicted by the testimony of secret witnesses.
Were they in the college parking lot?
They were.
Would you describe what they were doing, please?
Defendant Harley was standing beside the front fender of the car, holding a hubcap. Mr. Newland was down attempting to pry a hubcap from the front tire of the vehicle.
Did they see you?
Yes, sir.
What did they do when they saw you?
Started running.
Did you apprehend defendant Harley?
I did.
And did your brother officer apprehend John Newland?
Yes, sir.
Did you have a conversation with Mr. Harley regarding the charge in this case?
Yes, sir.
I have no further questions. You may cross-examine the witness at this time if you're ready.
The defense lawyer has the right to cross-examine or question prosecution witnesses without giving out evidence that will help the accused.
How many cars were there on that lot on this morning?
300 or 400, sir.
And who ran first, the defendant Harley or Newland?
Newland, sir.
Didn't you testify, officer, that you saw the defendant Harley standing by the car?
Yes, sir.
Officer Loggins, you didn't actually see the defendant Harley steal any hubcaps on that morning, did you?
No, sir.
No further questions, Your Honor. The witness may step down. Defense counsel, you may call your first witness. The defense called John Newland, Your Honor.
Raise your right hand to be sworn, please.
The Bill of Rights gives an accused person the right to compel witnesses to testify in his defense.